And thank you to Ruth and all the organizers for having me here to give opening remarks at this remarkable conference. So I'm going to focus my remarks on a pretty simple topic. What's toleration and why ought we to practice it? So let's start with a fairly simple and I think relatively uncontroversial characterization of what toleration involves. I take it toleration arises, the need for toleration arises when, say, one group of people disapproves of the practices or beliefs of another group of people, but nonetheless decides to put up with those people doing their thing. Okay? And toleration can be at issue between groups who feel this way about each other. It can be at issue between individuals. Right? I can decide to tolerate the beliefs or practices of someone that I disapprove of, but I'll just put up with them doing it. So the first thing to observe about toleration, right, is that it only becomes an issue when one group actually cares or has a view about what the other group is doing. Toleration is not needed when one group is simply indifferent to what the other group is doing. And I want to be clear at the start, sometimes indifference is the morally preferable attitude. Okay? Let me give you an example. So where I live near the University of Chicago in what's called the Hyde Park-Kenwood neighborhood, I live on a very diverse street. Actually, 2 blocks from my house is President Obama's house. That's fairly unusual. Fortunately, we're outside his security parameters, so it doesn't interfere with our life too much. But one of the striking things about this neighborhood is there are white families, African-American families, interracial couples, gay couples. It's an unusually, I think, diverse neighborhood. But notice, right, it would seem kind of strange to say, so one of our immediate neighbors, an interracial couple that's been there for years, they might take it the wrong way if I said to them, you know, I really disapprove of the intermingling of the races, but I'll put up with you living next to me. I'll put up with your decision about marriage. That's a context where actually you might think indifference is the morally more enlightened attitude. That is, not to disapprove of, for example, interracial marriage, not to disapprove of the gay couple that lives on the block. So sometimes we actually prefer indifference. Right? But there are plenty of contexts where toleration does have a purchase because we really do think that what some other group is doing is very wrong-headed, perhaps even morally objectionable, but still we ought to put up with it. But now I want to focus on the put up with part, because there's a lot of different reasons why we might put up with practices of which we disapprove. And what I'm going to be particularly concerned with tonight is what I'll call principled toleration. That is where we put up with the practices and beliefs of which we disapprove because we believe we have a moral obligation to do so, that it's the morally right thing to do. And the important point to see is that a lot of times one group puts up with another not for any moral reasons, not because they think it's morally obligatory. So let me give you a few examples. One famous example, which comes to us in the history of political philosophy from the English philosopher Thomas Hobbes, right, is the case where one group puts up with the practices and beliefs of another group of which it disapproves, not because the one group wouldn't dearly love to stamp out the other beliefs and practices, but because they think they can't get away with it without the intolerable cost of, as Hobbes put it, a war of all against all. So that's a kind of toleration, but essentially for egoistic or self-interested reasons, right? It's not that the one group says those people have a moral right to believe and practice things that I disagree with, that we disagree with. It's rather that the cost of trying to stop them is going to be too great. And I want to make clear that kind of Hobbesian compromise, as I'll call it, has played an important role in the history of the West, and sometimes it's the best we can hope for, right? Sometimes it's the best we can hope for. But notice it wouldn't be as, it's not as preferable and it's not going to be as stable as a society in which toleration is practiced out of the sense that it's the morally right thing to do. Toleration as Hobbesian compromise is always vulnerable to the possibility that the one group will say, you know what, maybe we can get away with actually changing the beliefs and practices of that other group. Here's another possible ground of toleration that's different from what I'm calling moral or principled toleration. This is an argument that is found in John Locke, though it is not the main theme of his famous essay on toleration. But one of the points that Locke makes, right, in arguing that the state ought to tolerate the religious minorities of which it disapproves, one of the points Locke makes is that belief, right, that believing something is a special kind of mental state, and that you can't actually coerce people to believe things. You can't coerce belief. You can't even incentivize belief. If I put a gun to your head and say, everybody here is going to believe that I'm a talking chicken, you can't believe it, right? Even if you think I'm really going to shoot. The nature of belief is you really have to take it to be true. You can't believe on threat. You can't believe because you're coerced. And Locke's point, notice, was that therefore, even if you wanted to be intolerant of religious beliefs that you thought were very wrong-headed and would lead to damnation, the state couldn't really do anything about it. Right? It really wasn't possible for the state to do anything because you can't coerce people to believe things that they don't genuinely believe. There's a similar line of thought that comes up in the context of American First Amendment jurisprudence on the free speech side of First Amendment jurisprudence. And the line of thought goes something like this, which is the reason why we, and actually let me back up one step. I mean, it's a curious and unusual feature of American free speech jurisprudence in comparison to the law of free speech in other Western democracies, that we are very, very, very tolerant of a lot of really egregious speech that's actually illegal elsewhere. Okay? So the famous example, some of you will remember the case from the 1970s, the Nazis wanting to march in a suburb of Chicago, which had many Holocaust survivors. The American Civil Liberties Union defended them. In fact, they had a constitutional right to march. There are many countries where they don't. In fact, there's almost, I would say, a consensus in the sort of countries that lived through the horrors of World War II that Nazi speech isn't worth hearing. Right? So the US is very different in this regard. And let me ask the question, why? Right? Why should the US be different in this regard? And here's the reason I think a lot of scholars, especially in the United States, tend to give, is, well, we have to tolerate it. We have to put up with it. Not because we think it's worthwhile or because it's morally good or because the Nazis make a contribution to moral knowledge and understanding, but because we can't trust the government to reliably discriminate between valuable and disvaluable speech. Now that has a similarity with the Locke argument in the sense that it says the reasons for toleration, right, have to do with our inability to be successfully intolerant. Right? To be successfully intolerant of the beliefs of which we disapprove, or to successfully regulate speech in such a way that only really bad speech ends up being restricted and not, in fact, speech that has considerable value. So those are all possible reasons why we might think that one group ought to put up with the beliefs and practices of another group of which it disapproves, or why the state should put up with or tolerate beliefs and practices of which it disapproves. But none of those are cases of what I mean by principled toleration. So what I want to suggest is that sometimes there are good moral reasons why you ought to tolerate beliefs and practices that you think are wrong, that you might even think are morally reprehensible. And sometimes this is often described as the paradox of toleration. How could it be morally right to put up with beliefs and practices that you think are morally wrong? That seems on its face a little bit paradoxical. But let me suggest some of the reasons that have emerged in the moral and political philosophy of the last 200 years that both point to the same kind of conclusion, namely there really is morally right to put up, not always, and I'll come back to that, but to put up with beliefs and practices that one might think are really morally wrong. So one line of argument is associated with the tradition in moral and political philosophy that is usually traced to Immanuel Kant in the 18th century, but receives its probably most famous articulation in the work of the American political philosopher John Rawls. Rawls's views will be familiar, I know, to many of you. So Rawls's basic idea was that toleration was going to be a requirement of justice. And it was going to be a requirement of justice once we understand what the basic principles of justice really are. Now, how do we arrive at the basic principles of justice? Rawls's thought was we need to engage in a certain kind of thought experiment, a thought experiment that will allow us to, as it were, bracket the partial self-interest and self-serving reasons we might have for wanting to organize society one way rather than another. And so in Rawls's thought experiment, he says, look, imagine people in what he calls an original position who are charged with the task of entering a contract, making an agreement among each other about the basic principles that will govern their lives. But the crucial thing about the original position, as Rawls thinks of it, is that the individuals in the original position are deprived of most of the information about what their lives will actually be like in that society. So you won't know whether you will be rich or poor, you won't know whether you will be black or white, you won't know whether you will be Christian or Jewish or some even smaller minority religious group in your society. The idea is you strip away all that information and people are going to agree on genuine principles of justice because they won't be influenced by their self-interest and impartial concerns. Now, they can't be stripped away of all information. They have to know a few things about what human beings are like. And one of the points Rawls makes is that they would have to know that creatures like us have a conscience. Creatures like us have a sense of right and wrong, obligatory, forbidden, and so on. And of course, that is a characteristic of all the world's major religions, that they have views about what's obligatory, what's forbidden. But it's also, of course, a feature of any claim of conscience that a person entertains. And Rawls thinks that in the original position, where people don't know, will my sense of conscience be in the minority in the society I find myself in, those individuals are going to say, look, there's got to be a fundamental protection for the liberty of conscience, because conscience is too important to gamble with. I can't just gamble that it'll luck out, that I'll be in the majority in my society. Right? I have to have some guarantee as a matter of basic justice that whatever I believe in the society in which I find myself, that there will be some sphere in which I can exercise my liberty of conscience, right, without being coerced, threatened, or punished by the state. So the Rawlsian argument gets us the conclusion for a broad scope of liberty of conscience, on the grounds that conscience is important to human beings, and that if we didn't know where we would stand in society, we would want to agree on a basic principle of justice, equal liberty he calls it, that would secure everyone's right to believe in accordance with conscience and to act to some extent in accordance with conscience. And I'll come back to the limitations in just a moment. So that's broadly the sort of Kantian or Rawlsian argument for why there's a moral obligation for the state to tolerate claims of conscience of which the state does not necessarily approve or which it may actively disapprove. And there's a very different line of argument, though it comes to a similar conclusion, that grows out of the moral and political philosophy of the 19th century utilitarian philosopher John Stuart Mill. And Mill's argument has been very influential in the free speech jurisprudence of the United States, and very influential in thinking about liberty in most Western democracies. So what was Mill's reason for thinking toleration was a moral requirement? Well, the starting point, of course, is that Mill is a utilitarian, so he thinks that the right things to do are what will maximize overall utility or happiness, as he sometimes says, in a society. Mill thinks, now this is the crucial move, Mill thinks that discovering the truth is one of the things that will maximize utility. And so then Mill asks the question, what are the conditions that have to obtain such that we will be likely to discover what's true? And I want to emphasize, because this is important for Mill, that Mill thinks there are not only empirical and mathematical and scientific truths, he also thinks there's truths about what the best kind of life is to lead. Right? And I'll come back to how that figures into his argument. So Mill says discovering the truth is going to maximize utility. Why then should we tolerate beliefs and practices of which we disapprove, especially if we think they're false? If we think they're wrong-headed, if we think they aren't, in fact, conducive to the truth. And Mill makes several important points. First thing he says is, look, we have to recognize we are not infallible. We may think we are in possession of the truth, but we could be wrong. And we're not going to find out if we're wrong unless we tolerate dissenting opinions, challenges to what we take to be, for certain, the truth. Secondly, Mill says, look, even if we're not completely wrong, even if we've got more of the truth than the dissenters, whom we would like to be intolerant towards, the fact that they have some of it, some of the truth, we're not going to discover unless we tolerate the expression of their opinions as well. But then third, and this is the most striking claim he makes, he says, let's suppose we, the dominant group that's thinking about being intolerant of dissenting opinions, let's suppose we're completely right. We've got the truth. Right? We believe what is actually true. Mill says it's still good to tolerate dissenting opinions, even though they're false, because when we are challenged by false opinions, we have to think more carefully about the reasons why we believe what we believe, so that we will hold our opinions for sounder reasons if we have to confront the objections to them, even if the objections are ultimately predicated on mistakes or errors. So even when we're wholly right, correct in our beliefs, there's still a reason, on Mill's view, to tolerate dissenting opinions. But now come back to the question of what's the best kind of life to lead. Because Mill thinks the same thing is true when thinking about the question, how ought I to live? How ought I to live? Mill famously thought that there could be such a thing as what we might call moral experts, people who had real insight and understanding into how it's best to live. Now, what would make them experts? What would make them experts is that they had relevant kinds of experience of different ways of living. And here Mill was breaking very strongly from his utilitarian predecessor, Jeremy Bentham. Bentham thought that happiness just amounted to pleasure in the absence of pain. He thought all pleasure was essentially the same. It differed only in quantity or degree. Right? So that the pleasure of listening to this lecture, or at least hopefully the absence of pain in listening to the lecture, is on a continuum with the pleasure of drinking good wine. It's on a continuum with the pleasure of going to your favorite sporting event, and so on. Mill says that's not right. He says happiness can differ not just in quantity, but in its quality. And the person who can discriminate the differing quality of different kinds of happiness is the one who has the relevant experiences. But of course, not everybody is in a position to explore every kind of possible life in order to figure out which ones are really produce the most happiness. And so Mill thinks, and now we're back to toleration, it's very important to tolerate what he calls different experiments in living. That is, to tolerate people pursuing different ways of living, because that will give us evidence of whether that way of living is really conducive to happiness or not. So when Mill famously says, and I'm paraphrasing slightly, it is better to be Socrates dissatisfied than a pig satisfied. What he's thinking is that if we permit ourselves the evidence of different experiments in living, we can see that the quality of the happiness Socrates, with his continual skepticism, doubts, and question, that the kind of happiness his life exemplifies is of higher quality than the happiness of the fat little pig rolling around in the mud, right? That is a lower quality kind of happiness. So Mill thinks we have to tolerate different experiments in living in order to even acquire knowledge about what's the best way to live. So tolerance is implicated both in our discovery of truths about the physical and natural world, but also truths, ethical truths, about how we really ought to live. So those are the two, I think it's fair to say, most important lines of thought in modern moral and political philosophy in support of a moral reason to practice toleration. Now, I want to come back to the issue I bracketed a couple of times, which is toleration has its limits. The Rawlsian argument acknowledges this, the Millian argument acknowledges it as well. In Mill's famous example, which has had a significant effect on American free speech jurisprudence, it essentially reflects the law in this regard in our country. It may be that we ought to tolerate someone writing an op-ed in the newspaper saying, this is Mill's examples, that corn dealers are starving the poor. But we shouldn't tolerate someone saying that to an angry mob outside the corn dealer's house, because it will be an incitement to riot. So for Mill, the limitation on toleration comes from what he calls the harm principle. Right? That our obligation to tolerate the opinions and practices we disapprove of hits its limit at the point when it harms other people. And this has a bearing primarily on the practice, not the belief. That is, there's going to be relatively few cases where the belief or the expression of the opinion, in the Millian view, is going to be a proper object of intolerance. Right? But practices may be a different matter. It may be that we ought to tolerate the beliefs of a religious sect who thinks my children are destined for damnation because I'm not a member of their religious sect. We don't have to, however, tolerate their wanting to kill the children of heretics in order to save their souls, right, from the terrible fate that awaits them. And so harm to others at some point becomes a constraint on what our obligations of toleration are going to be. So putting that now to one side, we've got two kinds of arguments about why there's a moral obligation to put up with beliefs and practices with which we disagree. That is, there's a moral obligation of tolerance, one flowing out of this Rawlsian line of thought, one out of the Millian or utilitarian line of thought. And so that gives us the answer to the question, why morally ought we to practice toleration? Insofar as toleration is founded on considerations like that, it's a good deal more secure, right, than if it's merely founded on Hobbesian compromise, or simply the sense that we won't be able to effectively be intolerant. But now let me raise a puzzle or a problem that these kinds of arguments leave us with. And this puzzle is in many ways the main subject of my book, which has the provocative title, Why Tolerate Religion, and the unprovocative conclusion that the reasons to tolerate religion are not specific to religion. Because you will have noticed that the Rawlsian argument from justice and the Millian argument from maximizing utility, neither of them singled out religion, right, as distinctively deserving of toleration. both of them gave us arguments for a certain kind of general liberty of conscience that would necessarily include religious claims of conscience, but they didn't lead to the conclusion that only religion should be the proper object of toleration. And that brings us to what is, I think, the problematic feature of at least American law in this regard, which is that it only singles out liberty of religious conscience for a special kind of legal protection. Liberty of non-religious conscience essentially has no standing before the law, or more precisely, no standing to challenge the application of the law in a way that would conflict with the individual's conscience. There is, for those of you who are lawyers, you'll know this, there's one exception to this in American law. And this arose during the Vietnam era when certain conscientious objectors to the military draft said, we have a conscientious objection to military service, but we don't have a religious basis for it. And the United States Supreme Court in a couple of cases concluded those people can in fact be conscientious objectors to the draft, but, and this is the important point for purposes of American constitutional jurisprudence, they framed that not as a matter of constitutional law. Because, of course, the First Amendment of the American Constitution says, right, that Congress shall not abridge the free exercise of religion. It doesn't say Congress shall not abridge freedom of conscience, free exercise of religion. The court did not want to read the First Amendment as applying to all claims of conscience. So when the court said conscientious objectors can conscientiously object to military service, even if they do not have a religious basis for that objection, the court treated that as a matter of statutory interpretation. They were interpreting the Selective Service Registration Act to mean, right, that you could be a conscientious objector without being a Quaker, for example. Right? You could have ethical objections to war. And they did that, again, very self-consciously in order to limit what the ramifications are. And that's the point I want to conclude on, which is if we think the moral arguments for toleration are good arguments, that there really is a moral obligation to practice toleration subject to the limitations of the harm principle, then we have to ask, what does the law do? What should the law do when the law comes into conflict with an individual's conscientious sense of right and wrong? Now, one possibility would be simply to expand the range of possible exemptions to laws of general applicability to anyone who can frame a conscientious objection to them, regardless of whether it is a claim of religious conscience or not. Predictions are usually dangerous, but this one I'm quite confident in. No legal system is going to adopt that approach, because it would in effect open the door for anyone to challenge any law on the grounds that they have a conscientious objection to it. And then the courts would, first of all, be overwhelmed, but then they would be in the rather impossible business of adjudicating the sincerity of the conscientious objection. Now, it's true that in the United States, in American constitutional law, the Supreme Court always says what counts is the sincerity of your religious objection to a law, not whether it's part of a recognized religious tradition. They say that, they don't mean it, because all the cases where they find the exemptions are always cases in which the beliefs are part of a recognizable religious tradition, and that's very understandable, because it's much easier to establish the bona fides of a religious objection to a law if you've got a tradition, if you've got an institution, if you've got written texts, if you can establish that the individual in question participates in the institutions and practices of that particular religion. There was a famous or notorious case many years ago where the Church of Marijuana wanted to challenge the application of the drug laws to their religious practice of smoking dope. The courts didn't buy it. They sized that up correctly as a fake claim. So even in cases of religious claims of conscience, you can have, dubious claims. But if we open the door to anyone to say this conflicts with my sense of categorical right and wrong based on my ethical, moral, political, cultural traditions, the courts are going to face a great difficulty, and they're not going to go that way. The other hard question about exemptions from generally applicable laws based on claims of conscience is that some exemptions are what we might call burden-shifting exemptions. If there is a law requiring military service, and I successfully claim a conscientious objection to military service and am exempted from it, then someone else is going to bear the burden of the military service, right? That's a burden-shifting exemption. Here's a more current case. Every state in the United States recognizes religious objections to vaccination, to mandatory vaccination schemes. Many of the states actually recognize what they call philosophical objections to vaccination. I think it's pretty clear they're not really scrutinizing it too hard. That is, it suffices to check the box to say, I have a philosophical objection. You don't necessarily have to write a sustained treatise explaining what that philosophical objection is. But let's just confine our attention to the religious exemption, which every state recognizes. Exemptions from mandatory vaccination schemes shift burdens as well, because vaccination only works to prevent disease if enough of the population is vaccinated. And due to the very liberal way exemptions are now given out, especially in the Western United States, we have the return of whooping cough out in California in the Pacific Northwest, entirely traceable to the granting of these exemptions. We have outbreaks of measles. In the worst case, we may even see returns of more serious diseases. Now, the point is, when you grant exemptions, there are costs. You grant exemptions, there are costs to the purposes that the law is meant to promote. My own view, and I'm happy to talk more about it in discussion, my own view is that we should probably grant fewer exceptions, except when the exemptions are not burden-shifting ones. But those exemptions should be available to anyone who has a genuinely conscientious claim. They are not burden-shifting exemptions. Simple example, right? When you go to get your photo taken for the driver's license, there's a legal requirement pretty much everywhere that you can't wear anything on your head. Okay? Now, the rationale for that is to make sure that the photograph is adequate to identify you. But it doesn't seem to me that any burdens are shifted if you make an exception for religious Sikhs, Orthodox Jews, to maintain their headgear that they have a religious obligation to wear, because it doesn't interfere with the actual purpose of the law. So sometimes exemptions are like that. They're not burden-shifting exemptions. But my own view is we've probably gone too far in the United States in the direction of carving out exemptions that really are undermining the pursuit of the general welfare. And having said that, I want to be clear, though, what toleration still demands, what principled toleration still demands. Principled toleration still demands that the state can't have as its purpose, however it frames its law, it can't have as its purpose to target and coerce the beliefs and practices of which it disapproves. And the Supreme Court of the United States has recognized that principle, right? They will sometimes look past the surface rationale. So in a famous case from Florida, a town in Florida decided that they were going to ban all animal sacrifices, and they rationalized it in general and neutral terms, animal welfare. The Supreme Court didn't buy it. The Supreme Court didn't buy it because the history of how the city council came to adopt the law made absolutely clear that they only became interested in animal sacrifice when a small religious group from the Caribbean started moving into the town and they practiced animal sacrifices. And the court said, I think quite correctly in this instance, that this was a pure case of intolerance. Right? That they weren't trying to promote animal welfare, they were trying to punish and coerce people for holding beliefs and engaging in practices of which the majority happened to disapprove. Right? So even if we were to change our view about exemptions to laws of general applicability, there still is, within the perspective of principled toleration, a strong requirement on the part of the state not to enact laws for the purpose of not putting up with the beliefs and practices of groups that are presently disfavored. Thank you.
Some questions, if there are any, and we do have microphones for anyone who would like to pose a question.
I'll put my traveling mic on now.
Hi, I just have a question regarding, you were talking about the religious beliefs of people, but particularly where the immunization occurs. I'm aware of a case with a nurse who said she didn't want the immunization because she was vegan. Now, is that going to be looked upon as a strong belief of a group of people?
Yeah, good. So, vegans are nice examples. I actually used them in the book, because it does seem to me that vegans have a strong conscientious reason for why they do the things that they do. That is, they are opposed on moral principle to the exploitation of non-human animals for any human purpose, right? So, vaccinations which are made from chicken eggs, right? That's an exploitation of the animals. Obviously, different vegans have different perspectives, but let's say that's the view. So that seems to me a case of a conscientious objection to the law that, under existing American law, has no legal standing, right? Unless the vegan could tie it to some religious reasons he or she has for being a vegan. But on my view, right, if we're to be equitable about this, then we have to acknowledge there can be a conscientious claim of the vegan's kind. Now, should we grant the exemption? My view is no. My view is no, because I think the costs to the well-being of society as a whole of exemptions in cases like vaccination are much too serious. Right? Now, that is not an uncontroversial view by any means, but that's my own view about that. That's what I meant by saying I think we as a society need to think a bit more. Right? There may be a categorical obligation for the state not to try to stamp out the beliefs and practices of vegans. But surely the state can try to prevent widespread whooping cough. And to do that, you have to have a mandatory vaccination scheme. To the extent there are exemptions from it, they should be for health-related reasons. That is, some people, right, are allergic to chicken eggs or whatever they're made from. Right? Those are more, it seems to me, reasons that do have to be taken into account. So if I were adjudicating the vegan case, while I recognize it as a genuine claim of conscience, I'd be very skeptical that an exemption ought to be granted.
Thank you. I was interested in the Church of Marijuana and the Supreme Court's reasoning for that there wasn't sufficient history, which seems to fit with the Caribbean group as well. But then there's the Peyote case, as I understand it, in which the Supreme Court said no deal. So I was wondering what was the problem there? Was there not sufficient religious history? And second, I was wondering, doesn't this make, I mean, I know your core point was that the reasons to tolerate religion are not specific to religion. But wouldn't that make the reasons to tolerate religion religious? What I mean is, the Supreme Court there is involved with determining what is a religion and what isn't. It's playing the theologian. And so, for those reasons to follow, we have to be working with a particular definition of religion. So I don't see how, the reasons.
So let me say something briefly about the second point and then return to the first case. I agree with you that in order to ask the question whether there are specific moral reasons to tolerate religious liberty of conscience, but not all liberty of conscience, we do have to have some view about what's characteristic of religion. The Supreme Court religiously avoids that. Okay? They don't want to go near it. They operate by a method of paradigm cases and analogy. Right? I, in my book, actually tackle this quite directly because I think you do have to answer that kind of question. Now, You might say, well, that's getting into theology. I'm not sure it is. It's getting into an analysis of what do we mean when we pick out certain sets of beliefs and practices, religious ones, but we say vegans are not religious, right? Or the pacifist, the non-Quaker pacifist has a conscientious objection but not a religious one. I think we have to answer that question. So I've got a chapter in my book that's entirely about this. But I think for reasons of time, I'm not going to try to summarize what I say there, but I actually agree with you that we do have to say something about that. Now, the peyote case. Let me just explain what the peyote case is. This was Employment Division versus Smith, a U.S. Supreme Court decision in 1990. Mr. Smith was a member of a Native American religion whose practices included the use of peyote. Now, peyote, I am told, unlike marijuana, I am told, I emphasize, okay, that peyote is apparently disgusting. That you chew it and it's apparently really gross. So it's not like, the problem with the Church of Marijuana was, it wasn't a genuine religious obligation these people had. They were just looking to get around the law. Okay? In the case of Mr. Smith, the Supreme Court recognized that the Native American religion actually required the use of peyote in the religious ceremonies. And of course, part of what made it plausible is that peyote wasn't very pleasant, right? You wouldn't, as it were, be using it unless you had a religious obligation. However, it includes in it something that was an illegal narcotic. Mr. Smith lost the job he had because he was subjected to a blood test and the narcotic element turned up. And then he filed for unemployment benefits. That's why the lawsuit is against the Employment Division. The state employment agency said, you're not eligible for unemployment benefits because you lost your job because you broke the law. And then he came to the Supreme, when it eventually got to the Supreme Court, and said, I want an exemption here from the law that says you can't have unemployment benefits if you lost your job because you committed a crime, because the crime I committed was a religious obligation of mine, given my religion. What the court said there is actually very close to the view that I defend in the book and was articulating a moment ago. And this was in an opinion, by the way, by Justice Scalia, who, as most of you will know, is on the conservative end of the court, but is sometimes surprising. And Justice Scalia said, look, we don't have to carve out an exemption from a neutral law of general applicability just because it conflicts with a religious practice. So he didn't deny it was a sincere and genuine religious practice. He didn't deny that it was required by this Native American religion. He just said the criminal laws don't have to carve out exemptions for people who have religious reasons for breaking the criminal law. It was a controversial decision at the time. It provoked an enormous backlash. Congress initially enacted, some of you may remember this, the Religious Freedom Restoration Act. That turned out in its original form to be unconstitutional, but the basic idea was Congress wanted to say, the difficulty is the Supreme Court in the United States successfully claimed for itself 200 years ago the authority to be the final word on the U.S. Constitution. There's nothing in the Constitution that establishes that. This is just, as it were, a successful practice they've established. So Congress can't come along and say, no, 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 that's not what the Constitution means. So what Congress eventually did is they said, we will constrain ourselves not to enforce laws in such a way that excessively burden religious liberty of conscience. Right? There are complications. There's a special law that deals just with zoning regulations. Religious groups often get exemptions from local zoning regulations on this basis. So even though the Supreme Court in that case took the view that, you know what, certain kinds of exemptions shift too many burdens, and so the state shouldn't have to grant them, it's largely but not entirely been undone both at the federal level and at the state level. Many state courts and legislatures have adopted more stringent standards for, they made it easier for religious claimants to get exemptions from laws of general applicability. So it's a strange moment in our constitutional jurisprudence of religion.
Thinking about litigation involving Muslims and Jews and other practices, is that the very jurisprudence that's meant to protect religious freedom actually is a very Protestant way of thinking about religion to begin with. For many religious communities, it's very difficult to distinguish manifestation from conscience and belief. So I'm wondering if you could speak to, in a sense, the Protestant foundation of the very principles that are meant to protect religious freedom, but then work against these very communities for whom manifestation of belief actually undermines the protection of very cherished beliefs.
Yeah. Okay. So I think it's actually quite right to say that the way we, in the post-Enlightenment modernity, think about liberty of conscience involves a certain kind of Protestant spin to it, right? Because, of course, part of the Protestant Reformation was to pit individual conscience against the authority of the church as an institution to say what religion required. Okay? And so I do think we are heirs to that particular revolution in thought. I'm actually very skeptical, though, that it depends a little on what you're saying about the practices in question, okay? That is, I don't believe that Muslims, Jews, or any other religious believers who engage in certain practices, right, do so mindlessly, like automatons. They do so because they believe they ought to do it. And so I think it may be the case that the conscientious obligation requires a certain action. That seems uncontroversial. But I'm not sure that we still can't use the framework of liberty of conscience to understand what's at stake, right, in these other religious traditions, even ones that are quite clearly not Protestant religious traditions. Now, if you've got a particular case in mind, we could talk about that. There may be particular hard cases, but in general, I think the liberty of conscience framework, and of course someone might say, oh, well, that Rawls and Kant and Mill stuff is all very nice, but I don't buy that. Okay. What I think is interesting about it is that I think it does tap into some very widely shared moral intuitions in the Western democracies, and that they give them a particularly nice systematic articulation that explains at least part of what we're trying to do, right, in the law governing religious liberty.
Thank you. I actually just wanted to pick up on Kant and Rawls and sort of ask you, there's a strong moralizing tendency in a lot of moral and political philosophy when talking about toleration, this idea that prudential or non-moral justifications for toleration are inadequate. In your talk, you sort of use the word secure, right? They're insecure. What we need are sort of moral principles, reasons for tolerating. And I'm just curious, I just want to ask you to say more about that. I mean, are you swayed by that distinction? A lot of times political theorists will want to couch toleration in terms of a kind of respect for persons. We can have respect for persons, but not for their persuasions. We can condemn their views without showing contempt for them as people. And I always find this distinction not particularly realistic and not particularly compelling. That's what I'm curious to hear.
Okay. So let me say two things about that. One is I think of demands for respect, right, as a different kind of moral foundation for practices of toleration. It seems to me to run into more philosophical problems as a plausible account of the foundations of our actual practices. So I'm inclined to think that the sort of the broadly Rawlsian Millian way is the more promising way as a matter of moral philosophy. But I won't be able to establish that in my response to you. But there is actually a chapter in my book that's about this question, about whether respect is the foundation. Now, on the initial part of your question, and I guess I said this briefly in my remarks, but it's worth emphasizing. Thank God for Hobbesian compromise. Right? I think religious toleration got established essentially on Hobbesian compromise grounds after the early modern wars of religion. Now, there's lots of real historians here. I'm not ones who I'm sure have more nuanced views about this. But there was a sense in which the conclusion was reached, we better put up with the differing practices of the various Christian sects, or we're all going to kill each other, right? And it's just going to be an unlivable situation. Hobbesian compromise is really important. All I wanted to say was that a society which understood itself to have a moral obligation of putting up with the groups and practices of which it disapproved is going to be one where toleration would be more secure. Because, as I said at the beginning, the problem with Hobbesian compromise is at some point one group might think, you know what, now we could get away with it, right? And it wouldn't be an intolerable war of all against all. Now, we can ask the question, can we have a society which has so deeply internalized a moral reason for toleration? I don't know. I think we have aspects of that in our society, but it's far from being, you know, I wouldn't say that if we could do a sophisticated Gallup poll, it would turn out that that's the reason most people practice toleration. So in real life, sometimes Hobbesian compromise is the best we can hope for. Sometimes the best we can hope for is to convince the intolerant, right, that they can't successfully be intolerant, right? Either because it's too costly to them, or they can't really, you know, change belief at gunpoint, right? Or that you shouldn't want to trust the state to discriminate between which religions are worthy and which aren't, and so on. So in real life, sometimes those are the best things we can do, and those can be quite good, right, given what the alternatives are.
Brian, I'd like to shift this a little bit. You talked mostly about setting limits on the state's intolerance of religious dissenters or conscientious dissenters. What role do you see the state having in regulating, mediating, intervening in the conflicts, the intolerances between groups or, you know, actors who are not the government itself? What's the implication for what you're...
Yeah. So, I mean, you're quite right that my focus, especially as I went on, was about limits on what the state ought to do vis-a-vis beliefs and practices that are disfavored. Okay? But issues of toleration obviously arise at an interpersonal level, right? They arise at the level of the social interaction between different groups, right? And you know, all kinds of moral issues arise about how people interact with each other and how groups interact with each other where the state isn't an active party. Okay, good. So my view is essentially that I think every state, right, stands for what you might call a vision of the good. Right? Every state stands for certain kinds of values, right, that they think are important values. You know, United States, right, through its schools, through the public pronouncements of its officials, stands for liberty and justice and equality for all. The schools, right, typically also stand for toleration. Insofar as states adopt certain moral values as important, there are things they can do, as it were, to affect the social fabric, right? How people interact among each other. Sometimes that's just going to amount to matters of exhortation, required curriculums in the public schools. Sometimes it can involve more serious, right, interventions by the state. I mean, look, think of many of the major civil rights laws, right, which indeed had a moral animating purpose, right, and ventured into realms that were before that not thought to be ones where the government was going to get in. I mean, who would have guessed in 1930 that the United States government could tell private hotel operators you can't discriminate based on race? But that, of course, was one of the upshots of the civil rights laws of the 1960s. So that's a case, right, where we're using the law, right, to prohibit an intolerant practice, but partly also with the hope of shifting and changing people's attitudes. And to some extent, the civil rights laws actually have had some of that effect. We're seeing something similar going on right now with the debate about gay marriage. Right? That is, if the state puts its imprimatur on the legitimacy of gay marriage as a kind of marriage the state recognizes with all the privileges that are involved in recognizing it as marriage, that is bound to have an effect on interpersonal and group interactions, right? And the standing of gay people as equal citizens in the society. So I think, the government ends up doing those kinds of things quite a lot. And as I say, it's on a spectrum of exhortation, public school curriculums, all the way to actual legal interventions. Now, I will say we have to be careful about one thing, which is that insofar as the state has an obligation to tolerate, right, dissenting beliefs about the state's own vision of the good, there may be a limit to how far this, right, should really go. So I think it would probably be a bad thing for, shall we say, to criminalize interpersonal intolerance. Right? You might say people ought to do better, but I can think of lots of reasons that take away nothing from toleration, but I think lots of reasons why we wouldn't want to make it a criminal offense, right, for someone to be interpersonally intolerant of another person based on their race or their sexual orientation or something. But that's different from saying the state shouldn't, in fact, recognize gay marriage, that the state shouldn't prohibit discrimination in employment, discrimination in the provision of services in the marketplace, and so on.